I am focusing on conditional residence orders, and the case in particularly that I have focused on is children, and it's a 2012 case, Mr. Justice Peter Jackson. It's an oldie but a goodie, and one that I don't think is well known, and certainly a tactic that is not being used in private law proceedings. Essentially, the headlines from that are that the court has the power to make a residence order essentially in favour of the non-resident parent to come into force if the resident parent does not obey the court order and make the children available to spend time with that parent. That type of order is time limited for an automatic transfer of residence. So, for example, in this particular case, it was time limited for 8 weeks. And then thereafter, the court made a further longer order for 12 months to the non-resident parent, who was the father in this case, for him to be able to restore the order for an early decision if the children were not made available for any subsequent period of contact beyond that was in the initial time-limited period for automatic transfer of residence. The factors that need to be weighed into account when you are making these applications, first of all, principles remain the same. The welfare of the children individually and together is paramount, delay is prejudicial, and in intractable cases like this, a very careful analysis of the welfare checklist is essential. What does the court need to do? Well, the court needs to answer the central question: why do the children not want to see the non-resident parent? And then will the parent who currently has the children in their care change their approach? And if a change of residence is being thought about, is it inevitable and not just possible? The court needs to identify the realistic options for the children and then balance the for and against, looking at the whole picture in the short, medium and longer term in respects of losses and harm. Once the court has decided it's in the best interests of the children to have a relationship with the non-resident parents, then the court takes the view, or did in this particular case, that it is wrong then for children. In fact, I think the phrase is plainly wrong, for children to learn that it can be ignored or defied in terms of obeying court orders. Two particularly interesting points of note for reference: wishes and feelings are important, as they are in all cases. But the critical importance is to distinguish between real wishes and statements children make. And the judge saw the children himself in this case and evaluated for himself. And then finally, separation of half siblings. It's difficult. It brings with it great loss, but it is not a total loss, as may be the loss of a parent if the children aren't moved. That's it from me.